tight and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
And the real good one is here with you, David Whiting, well-known Melbourne solicitor, here to answer your calls and solve any problems you might have. Legally related, of course. 1300 222 774. David Whiting, good morning.
Good morning, Virginia.
What's news?
Not a lot.
Any homework?
I had some homework. I spent lots of last week trying to write a COVID-safe plan because we're all back at the office now, and that took an awful long time. And then, of course, on Friday the rules changed. So, but we've managed to get one. Homework was Phil from Wodonga. Phil's query was in relation to he found out that a child he thought was his was not his, and he wanted to know whether he had the ability to bring up an action against the birth father, the natural father. And the answer is that I've not been able to find an Australian case on that, but found some American ones. In 2003 or 4, there was a case launched in Victoria where a person who was paying child support, after a DNA test, found he was not the father of the child for whom he was paying support, and he sued the mother. And he sued the mother in deceit on the basis that she knew who the father was. The matter ultimately went to the High Court, and the High Court said that's an inappropriate use of the deceit proceeding. And he was unsuccessful, and then they changed the law. So Section 66 capital X of the Family Law Act now allows you to sue the person who pays the child support to recover it from the person you pay it to, which is clearly not the same as the person who's the other party to the conception.
Right,
so
okay.
There's no really clear answer for Phil.
Yeah. And it was a deeply emotional issue as well. Perhaps the representation of it in our conversation may have been a financial one, but in further discussion with him, it was clearly, as you would understand,
incredibly emotional.
Far more complicated than that. But it was representing itself as perhaps a seeking some financial compensation. But in the end, that might not help or be of any use. But maybe we can be of use to you. 1300 222 774. David Whiting can answer your questions today if you have some. Rebecca in Hyatt, how can we help you? Go ahead.
Oh, hi, Virginia and David. Thanks for taking my call. Look, it's about a gate, and we are a back house, and there is a house in front of us, and our driveway goes along the side of the front house, and along that driveway is a gate. So it's a gate that only we use at the back, and I just wanted to see, it's getting a bit old, and I wanted to see what our options were in terms of replacing the gate.
So this is a gate which only provides access to you?
Yes, it does. And the trouble is that we didn't put the gate there. We bought the house with it as it is, but it's in the wrong spot. And it's
is the driveway common property, or is the...
Yes, and it's on the common property. So the common property is... It's on the common property, and it's not... It's 5.5 metres in front of our private property, if you like. So had it been built in the right place, it would be 5 metres towards our house, and that would be on our boundary and not on... So it's currently on the common property, and that's why I'm sort of struggling with.
So it's between the common property and someone else, or is it like 5 metres from your property but across the driveway?
Yes, across the driveway. So it's fully on common property.
So both sides of the gate are common property, so the 5 metres from the gate to your house is still common property?
Yeah. So, in other words, I guess when we close the gate, we've got 5 metres of extra sort of common property.
And what do your neighbours want to do?
Look, we don't have the best relationship, and we don't really care ourselves whether we have to move it backwards or we can maintain it in the position that it's in. I just wanted to know if
Rebecca,
replaced it,
there are two parts to the problem. The first is that if there is no maintenance plan for the owners' corporation, then you're going to have to deal with a provision that basically says that if you benefit from the gate, that you pay for it. I would be suggesting that somebody write to the neighbour with a copy of the plan and where you propose to put the gate, and use that as the basis for your starting point and whether you want them to contribute or not. But given that it accesses your property only, you may rather not.
Hope that was helpful to you, Rebecca, and thank you for calling in. Trudy in Williamstown, go ahead.
Oh, hi, David and Virginia. Thanks for the call. David, I just wondered what I could suggest to a friend. She was injured in a workplace accident end of October, and the employer's been sitting on the paperwork since then and still hasn't lodged the work cover claim. So she's been without income since then and will be for weeks to come. I was hoping to get community legal centre advice, but they don't deal with work cover. So I wondered what I could suggest she does to try and force the issue at work.
Does she know who the insurer is who is looking after your friend?
No.
Then you might like to...
Should they tell her that? Is that something she should be
well,
able to get from them?
I don't believe that the insurer has an obligation to tell her who their insurance management is conducted by, but it might be appropriate to contact WorkSafe and make a complaint. Right now, we have one workers' compensation insurer in Victoria. That's Work Cover. It's Work Cover, and they have they have claims managers. So there are insurance companies that manage groups of customers. So for Work Cover, so complain to Work Cover. Turn around and say, look, I've got a complaint. I've heard nothing back, and my employer isn't helping. So what you really want to do is get the insurer, Work Cover, to put some pressure on the claims manager to get a claim out of your employer.
So, am I right in thinking a claim needs to be lodged within 30 days of an accident?
It doesn't automatically follow that. It wouldn't result in the rejection of the claim. It's to put pressure on the employer to move things along. So it won't impact upon your friend's position in relation to the claim or the job.
Get things moving so she can get some pay. She hasn't been paid for weeks now,
Well, she should be paid by the employer. Normally the process is that the employer becomes the agent for making the payment.
Yes.
So she would continue to get wages via her employer.
Hope that's helpful, Trudy. Thanks so much for calling in. Pat in Mornington, what's going on there?
Oh, good morning. In the wind the weekend before last, a huge cypress that was growing in my neighbour's property has split in half, and half has fallen on a shed in our backyard. Do we claim on our insurance for the property damage done on our side of the fence, or do the neighbours have to pay for it?
I would be asking the neighbours to make a claim on their insurance policy. If you make a claim, it will affect the premium you pay, and you'll need to pay a fee for making the claim. So I would be talking to your neighbour about them making a claim to deal with the whole of the tree, not just the bit that fell on their property. They could make a claim on your insurer, and it's even possible that you have exactly the same insurer, but I would start with getting your neighbour to make the claim.
Okay, hope that's helpful, Pat. Thanks so much. 1300 222 774 if David Whiting can help you with any legal challenges here. Rosalind's called in from Glen Waverley. Rosalind, you've got some issue with some legal paperwork, is that right?
Yes. In the process of printing out my mother-in-law, she's elderly, 93, her proof of vaccination, I discovered that the reason we're having difficulties is because all the documentation's in funny names. So we've got 10 different names over 20 documents going back to the 1950s.
Are all of the names recognisable as your mother's?
Yes, mostly. They're different spellings on a theme, but the main thing I need to do is get her Medicare name sorted because everything else comes off that.
Yes.
I mean, I have been able to get her proof of vax done, but I'm just in the process of doing the other document. Now, the one I wanted to ask you about is my brother-in-law has an enduring power of attorney legally and medically over her.
Yes.
They are both in a misspelled name. Her Christian name is correct, but the middle name has the second and third letters reversed.
Yes.
Now,
so it's a typo?
Yes, possibly. So
Right.
is that still valid or does it need to be redone?
It's really a question of where you want to use it and what issue they take. The purpose of names and addresses is to make sure you've got the right person. And if there are two letters reversed in a name, it's particularly not the first or the last name. It's quite possible that no one will pick it up. My view would be I would get the document redone.
Yeah, that was my inclination because, as I say, it's a bit of a mess. I mean, it's...
Well, if somebody takes issue with it, you can't fix it.
Well, indeed, yeah.
So while your mother-in-law is still competent, I would do something about it.
Okay, and the only other thing I wanted to ask about the power of attorney, is there any reason why more than one person couldn't have the power of attorney? Because I've been lumbered with the job of controlling her medical decisions, but I actually don't have the power of attorney.
For medical decisions, what you need is a thing called a medical treatment decision maker.
Okay.
There's a document that appoints... It used to be a medical treatment power of attorney. It's now a medical treatment decision maker form, and there can be a list of people on it that the health provider will call in order depending upon how important the answer is. And so if you're going to read it, it's the same kind of thing. You can download a form at the Office of the Public Advocate, so opa.vic.gov.au, and there's a form there that you can use. Or alternatively, when you're getting the powers of attorney redone, you could get it done at the same time.
Thanks, Rosalind. Hope that's helpful. Tony in St Kilda, you're not ringing in to talk about taking on car parking officers, are you?
No, I'm not. Hi, Virginia, David. So I live in a car apartment complex, and within that complex there are a number of visitors' car spots. The body corporate have decided that no resident shall use those car spots at any time, and if you're a visitor, maximum of 2 nights. If you violate those rules, the body corporate will call City of Port Phillip Council to allow the parking inspectors to come in and issue a fine.
Yes.
I spoke to the council. I said, are you allowed to go on private property? And they said they have a legal agreement between the body corporate and the council to do so. So I'm just wondering
Tony, what you need to do is think of supermarket car parks, right, which are clearly private property. And some years ago, we had all sorts of issues with people putting clamps on cars that were thought to be inappropriately parked, and we dealt with that one. And there is often an agreement between the supermarket and the local council, allowing them to administer their bylaws on the council property. So if there is an agreement between Port Phillip Council and the Owners Corporation in relation to common property, and I think you'll find that the visitors' car parks are common property, then it would be a valid and enforceable agreement.
Okay.
All right.
That's
okay.
it.
Good luck. Well done. Maureen in Bacchus Marsh, what's going on? How can we help?
Hi, Virginia and David. My query is about surnames. My daughter's getting married in a couple of weeks, and she wishes to take on her married name, but she wishes to keep her maiden name for professional reasons. Is this possible, and how do you manage tax returns and other legal documents?
Well, she needs to decide what she's going to be and when she's going to be it. When people get married and adopt their partner's names, they normally do it by usage and not formally. So enrolling children at school, she might be a Jones and becomes a Smith. You would normally just enrol the child for Mr. and Mrs. Smith. So you would keep everything. So you need to work out, what do I want in my own name and what do I want in my new name?
She wants her married name so that she has the same name as her children, so she wants that legally. But she's going to be a vet, and she wants to work as a vet and have all her work things then legally in her maiden name, because that's what all her professional certificates and that have.
Well, let's take it. She could register as a vet in her maiden name because she will have a degree. She'll have evidence of a qualification there. But she needs to think about, what do I want on my driver's licence? What do I want on my tax return?
That's what we want to know how to handle, yes. Which one do we use or can use either?
No, I'd rather you didn't use both, but you can use either. But if she's going to be Mrs. X for everything other than her professional work, then the answer would be, I've got married, here's my marriage certificate, I now want you to change my bank account, my driver's licence, talk to the accountant about getting the tax registration changed. It's really quite straightforward.
Oh, okay.
It doesn't sound like it's terribly straightforward to Maureen, though.
Oh, okay.
David.
No,
Right.
so legally everything's going to be in the married name, but just for purposes of work, she's just going to say she's got a maiden name. Is that about it?
No, she's going to continue to be X while before for her professionally, and she's going to be Y for everything else. So you go into the bank and say, I've got married, here's my marriage certificate, I'd like to change my bank accounts over. You go to Vic Roads and you say, I'm now Smith instead of Jones. Here's my marriage certificate as evidence of my change of use of the name.
But I want to be called here, here and here Smith, the original Smith, and not changing to Jones. So it actually won't be a documentation thing. But what about if she's known by her original name in the workplace, but her bank account is in her changed name? How does that affect being paid?
You just tell it you want it paid into that account. I would be telling the payroll people, put it in this account.
Yeah, because I guess you could give any account, couldn't you? It doesn't have to
Yes,
be your
it
account.
doesn't, no.
Yeah. Okay, all right. But it's an interesting conundrum there, and I guess I can understand the challenges, particularly if you want to keep the same name when it's in relation to kids.
If people want to change their name formally, you do it by making an application to Births, Deaths and Marriages, and that's a fairly straightforward process. But the problem would be that Maureen's daughter wants to continue to be what she is now for some parts of her life.
Yep, okay. Michael in Bundoora, what's going on there?
Yes, thank you for taking my call. I wish to sue a company that's in the motor car trade, and I appealed to VCAT. VCAT informed me that they could not take action because the company has been in receivership, and the company has been in receivership, as far as I can find out, for at least 5 years. They told me to seek leave to appeal to the High Court.
Wow. How much is your fight over, Michael?
Well, I had a look at the... I investigated that, and the step one would have cost nearly $2,000.
No. I want to know how much is your argument?
$4,500.
Yeah, my view would be you will blow that within a week.
Yeah, that's why.
Michael. Okay, Michael. What happens is this: is a receiver is like a mortgagee.
Yep.
And they take possession of the assets and they deal with the assets. At the end of a receivership, one of two things happen. The company is returned to its owners and leaves receivership, or the company is placed into liquidation. All right,
yeah.
So what you might find is that the company is both in liquidation and there's a receiver.
But it's been trading for nearly 5 years in this situation.
Yes, they're trading out. Yep. But it's not them trading out. And is your action earlier than the receivership?
Yes. No, sorry. No, it's not.
So then your action is against the receiver. Right? So your action, let's call it a retail outlet, and a receiver is appointed and runs the business. Your action is against the receiver and manager.
And how do I go about that without taking out a second mortgage?
Well, that's a VCAT matter, because your claim is against XYZ Proprietary Limited, receivers and managers appointed.
Okay, so I can go back to VCAT.
And you can go back to VCAT and you say my claim's against the receivers.
Okay, thank you very much.
Thank you, Michael.
Thank you.
Excellent. You mean we actually just had a VCAT recommendation story that ended with a happy ending? I don't believe
I don't know about happy. Current delays at VCAT for most things are 2 years.
Yeah, well, it's not happy at all. We can fit in one more, David, before you sprint out the door. Oh, but my goodness me, who should it be? Bernie in Baldwin, go right ahead. Hello.
Oh, yes. I'm just curious about how to do a letter of demand to get compensation for damage to floorboards by a contractor when they put a stone bench in.
What happened to the floor?
They dropped stone on the floorboards and it gouged the floor.
Oh, is it a nasty hole, a gash they've made there?
There are quite a few gashes on the floor.
Okay. David?
Bernie, do you have any indication of what it's going to cost to fix the floor?
I have got a feeling it might be upwards of $10,000.
So my starting point would be, what's it going to cost to fix?
Get the quote.
So I would be getting a quote. I'd be coming along and saying that this didn't exist before you came. It all occurred while you were in. So a letter of demand is you would recite that they installed a stone bench top. that during the course of the installation they dropped stones and damaged your flooring. You've got a quote to get the flooring fixed. Here's a copy of the quote. You would like them to pay you the amount of the quote and you'll attend to getting the floor done.
Oh, okay, right. Okay, yes, that does make sense.
It's not a magic form. There are in the lawhandbook.net.au, you can have a look there, and they have letters of demand that you could adapt, things following a car accident. You don't, if you're going to VCAT, I know we're talking about VCAT again, you don't technically need a letter of demand. If you're going to the Magistrates Court, you're supposed to send one first.
Okay, and very quickly, let's hear from Bruno in Pascoe Vale. How can we help, Bruno?
Good morning, and thanks for taking my call. My mother-in-law's been served, who's 76 years old and not in the best of health, has been served with an AVO.
Can I ask by whom?
By the person who owns the property next door to her.
Okay.
Yep.
All right, over a dispute over a tree.
Right.
And she didn't physically intimidate anyone, threaten anyone. She got some legal advice saying that she should just accept it and just let it run out, or just let it run its course, and that would be her cheapest option. What would you do?
I would be,
any other way?
And Bruno, this isn't the time, but the real question is, what are the accusations made against your mother, and what's her view in relation to them? So, if she's accused of saying things she didn't say or do, then you go to the magistrate. Now, and is this been issued by the police or by the man next door?
Well, we need to know. This is in New South Wales. Is that right, Bruno?
Yeah, correct.
Does that change the matters, David?
No, it doesn't change the process.
Okay, all right.
You need to know whether it's being issued by the neighbour or by the police, because if it's been issued
from the police.
No, the police serve them anyway, but one would be the complainant would be the police, the other complainant would be the neighbour.
No, it's from the neighbour, definitely from the neighbour.
Okay, then it will just going to take forever to drag through the Magistrates Court in New South Wales. So what she does is she says what she's effectively doing is denying the claim and wants to be heard.
So she should actually do that, or
my difficulty will be I haven't spoken to the lady concerned. I don't know precisely what the allegations are. And it's really a question of, is the issue important enough for your mum? If it is, do something about it.
Thanks, David. Excellent advice there. We'll see you next week.
I'll be back.
David Whiting there, dispensing his free and wonderful legal advice.